Hello, good morning, students and scholars. I'm Andrea Saldivar from the International Affairs Coordination. The National Autonomous University of Mexico, through the assistance of the Division of Postgraduate Studies and the International Affairs Coordination, as well as in partnership with Chicago UNAM, is delighted to welcome you to the third session of the seminar Relevant Aspects of the North American Legal System. I must remind you that in order to record your attendance, you must enter the session with your full name. Additionally, if you have questions during the presentation, please leave them in the chat. There will be an indicated time to give them answer at the end of the lecture. Today's meeting will approach the differences between the common law and the civil law. In this manner, I am pleased to introduce Professor Manuel González Oropeza, Law Professor at the UNAM. Manuel González Oropeza is a researcher at the Institute of Legal Research at the National University of Mexico, and a professor and supervisor of the Graduate Division in the School of Law at the same university. His publications are concentrated in high areas such as legal history, constitutional law, comparative law, and electoral law. He earned with honors a law degree in 1980 from the School of Law of the National Autonomous University of Mexico. In 1982, he obtained a master's degree in public law from the University of California at Los Angeles. And in December of 1995, he received the honoris causa Doctor of Law degree from the National University of Baja California. Professionally, he has served as General Secretary of the Department of Humanities at the UNAM, Bureau Chief of the Diplomatic Archives of Mexico at the Department of Foreign Affairs, Law Clerk of the Supreme Court of Justice, Chairman of the Electoral Council of the Federal Elections Board at the Federal District, which organized the first election for head of government for Mexico City in 1997. He has been a professor in various states and private universities throughout Mexico and abroad. From 2006 to 2016, González Oropeza serves as judge of the Supreme Court of Elections in Mexico. He has also been alternate member in a personal capacity of the Venice Commission for the Council of Europe, accredited by the Mexican state. Please welcome Professor Lo Luis.
González Oropeza.
Sorry, Professor Manuel González Oropeza.
I would like to be Professor Luis because he's so white, but I'm González Oropeza, as you mentioned. Good morning. I'm sorry for the misunderstanding that probably the organizers had because they didn't allow me to enter this section. First of all, I think that this is a great event. And it's a great because not only means the coordination between the universities in Chicago and Illinois and our own university. In fact, I would like to begin that saying that these kind of events should be continuous and should be organized, but even in a broader scope. Now, because of the pandemic and the illness that we suffer all worldwide, excuse me, Claysita. Now, as I was saying, the pandemic teach how to conduct classes by Zoom and conduct classes, and I would like to put myself on the screen where Andrea is. I don't know how can I do it. Well, okay. As I was saying that the delegation of our university in different cities of the United States and even in Canada and in Europe should be the basis for the organization of courses, not only for learning language, Spanish language, which is good, very good, but also to conduct classes in specific and material classes. We have a very dynamic dean at the University of Mexico in the law school. So I think that he might be interested in organizing courses for in law. I was with you, accompanying you in your previous sessions, and there's a lot of interest for you that you can learn and earn a degree in law in Chicago or in the United States. And that is wonderful. I myself got attracted with that purpose some years ago when I studied at UCLA. And unfortunately, our authorities at the time, they didn't allow Mexican students to teach, to learn law and to study law abroad. But I found a good way to go around this impediment through the political science department of UCLA, in which at the time they had this section for public law. It's a legal section in the political science department. So I earned my master's degree in political science in law through that door. And this is interesting. But I was learning that some of you would like to, for instance, to apply for the graduate courses at the School of Law in Chicago. But you are foreign lawyers or foreign students. And I think that why not try first to apply in your own university at UNAM and to register at UNAM in graduate courses. I teach at the graduate level at the law school, and we receive students from other countries as well, and learn a master's degree or even a doctorate degree in law in the University of Mexico. As you can see, the law degree in the United States has a different number of years. You have to study undergraduate courses in whatever specialty you want, economics, political science. I think that even Professor Swinsik said that he has been primarily an anthropologist, and then after a lawyer. So you study 4 years in college for whatever undergraduate degree you want, and then after that, you study 3 more years in the law school for earning a basic law degree that, even though it's called JD, Juris Doctor, is not a doctorate degree. It's just a undergraduate degree or graduate degree in law, but it's the first basic level in law. After that, you might go to other studies. As a matter of fact, there's a JSD, a Juris Doctor at the doctorate level, but very few students go to those kind of levels. In other words, I think that this is an open window for future collaboration and for all the delegations of our university in order to organize courses in substantial matters like law. And if you want to study law in Mexico, you can do it not only going to Mexico City or going to the university campus, the main campus, but probably you might be interested in having law courses through the delegations of UNAM in these different cities. Now, let me tell you since the beginning that there's advantages in these views. As Professor Swinsik told us yesterday, the law degree in Mexico is national degree. If you get a law degree in a Mexican university, you can practice law everywhere in Mexico. You are not restrained by any bar examination. You are not restrained by any other, because the title is given by the university, and the university in Mexico is national. It's a national authority. Whereas in the United States, you go to the university first, and second, once that you are graduated in that university, you have to submit a bar exam in every state. Of course, there are some states that they are attractive: New York, California, etc. Illinois, I think that is also attractive for lawyers. But the understanding is that you only practice law in that state, with one exception that it was mentioned yesterday, and it's called with some name that is a kind of authorization from the lawyer in one state and asking to the bar of the other state to litigate just one single case that he is interested. But that's an exception. Okay, this is my first remark. My second remark, I would like to stress, is that webinar or seminar that we are taking is relevant aspects of North American legal system. That means that we shouldn't be only interested in learning the United States and Mexico. Somebody in the United States, they doubt that Mexico is North America, but partially it's North America and other parts are Central America. But we should include Canada. And Canada is close to Chicago and close to the professionals that live in the border with Chicago. And Canada could also be incorporated in the future seminars to have precisely relevant aspects of the whole North America. The legal system in North America is different from the United States, because Canada has a mixed jurisdiction. It has common law and civil law. Even the United States has some states with mixed jurisdictions, like Louisiana, for instance. That means that they are regulated by civil law in one part of the disciplines, and the other is common law. But the civil law is also included in the legal system of these countries of Anglo-Saxon ascendancy. And I think the Canadian system is also quite interesting. Public law and private law is quite interesting. The private law is mostly civil law. Now, what is civil law and what is common law should be the first question that we raise in this kind of seminars. Civil law is related to the law that we practice in the countries that relate mostly to in most countries to legal system in which is basically statutes, codes, and legislation. That's why, for instance, in our constitution in Mexico, we have had more than 700 amendments. If you say that to any American scholar or even Canadian scholar, they will be surprised to find that we have so many amendments, and we are continuing to do the amendments. We are endless. Our constitution is the oldest written constitution in America from the civil law, but of course the United States is the oldest of everybody, but it has only 27 amendments in more than 200 and something years of enforcement. But we have from 1917 to the year today, we have more than 700, and I think that we are approaching 800. That means that in the system in our countries rely mostly in the legal aspects of the codes, of the statutes of the Constitution. Our Constitution can be considered or described as a codification of the principal laws that regulate the government and the human rights. So for our lawyers, it's enough to study the wording of the Constitution or the statutes and to present an exam in the university in which we studied, and probably sometimes to write a dissertation. But the dissertation is not exactly the only system that we have. And in contrast, the common law is a graduate degree for lawyers, and they have to study cases and the law that is made by judges. This law is not exactly to learn the wording of Article 3 of the Constitution of the United States, or the First Amendment of the Constitution, the wording or the letter, but the interpretation by judicial courts, common law. For that respect, common lawyers don't need to have a specific and exhaustive written document in which all the details of the course are specified. On the contrary, as the text is broad, there's a margin of interpretation for judicial courts. We cannot understand why a constitution enacted in 1787 is still in practice now in 2023. How is that possible? In Mexico, a constitutional disposition enacted in 1917, we have amended or reformed the article several times. Article 73, for instance, of the Constitution is the article that established the legislative powers for the Congress. And every time that we have a federal question, we think first to reform the Constitution to specify that federal power granted to the federal government. That is not necessary in common law countries. That is not necessary, and the judicial interpretation of the constitutional disposition is the main point to develop the new theories and the new concepts in the Constitution. The right to be, the right of freedom of expression, for instance, in the 18th century is not exactly the same freedom of expression that we have in the 21st century. And the adaptation has been made through judicial decisions in different courts cases. So common law doesn't need to have specific, explained, detailed dispositions in the law, written in the statutes or in the Constitution. But it has a dynamic in the cases that had this power to interpret the Constitution and the statutes. The validity of the degree in civil law countries is national. As I said, if you are study in the University of Nuevo León, for instance, in Monterrey, in northern Mexico, and you graduate from that university, you can go and practice law everywhere in Mexico. Of course, once that you fulfill the requirements of the Mexican legislation. And the common law countries are very fragmented. They are very piecemeal, and you need to overcome different obstacles, as many as 50 obstacles, because there are 50 states. One of the main aspects in this examination is the bar. Since 1878, there was an American Bar Association created to regulate the legal profession in certain ways. It's the bar and not the university who gives the authorization for any law practitioner to practice law in every jurisdiction. It's considered that 35% of the students who have achieved the studies in legal background, they take the bar examination as soon as possible, as soon as they graduate. But others, 65%, they wait because they have to prepare and they are doing work, researching or studying, completing the knowledge to face the bar examination that sometimes is quite difficult. Every other occasion, we have, for instance, 4,000 applicants for any bar examination. New York, for instance, or California, they have 4,000. And as Professor Sinsbeck explained yesterday, they are divided into 2 days. And some of the people, even famous people, they fail the bar examination and they present another bar examination later on. In recent days, I read that the actress Kim Kardashian, this Armenian actress and a beautiful lady, she failed the bar examination and she's preparing for present another test. On the other hand, the Bar Association also looks for infringements in the ethics. Rudy Giuliani, the famous mayor of New York, for instance, who he was considered to be a non-reliable lawyer because he lied so many ways for the election on behalf of President Trump, that he's been suspended. His bar He has not been barred, this bar, as they say, he is not expelled from the bar, but he's been suspended as a lawyer, precisely because this lack of ethics in the conduct of the testimony in the election. The American Bar Association is quite important. And they certificate the law schools. All the law schools in the United States are certificated or certified by the American Bar Association. And this makes the organization quite interesting and quite powerful. Also, the association is consultative for the candidates of judges who will be judged and what kind of guidelines they have to be. Is the American Bar Association the organization that faces the guidelines in this respect. Our history in Mexico and the United States, they are not so distant. In fact, many of our features of our legal systems are shared, especially in the southern border. There's one case that I would like to advance, is the case of California. When California was invaded by the United States, California could be cataloged as a slave state, like Texas, for instance. But because of the wealth of California, and because other historical circumstances, California was, since the beginning, a state, a full-fledged state. And in the legislature of the state, that it has its seat in the city of Monterrey. There's another Monterrey in California, very nice town. They face a debate very interesting about the advantages and disadvantages of the common law versus the civil law. California, as a territorial province of Mexico, New Spain, they had at the beginning the civil law jurisdiction. But now that they're becoming a state in the United States, they were studying what kind of legal systems they might adopt. And they adopted the common law system since the beginning. However, the arguments that they advance in the debate are a little bit interesting. The state legislature condemned the civil law as a law that is minor in advancement in progress than the common law. They emphasize that the civil law does not recognize the jury trial and does not recognize other features of the common law. Juries were very important for the common law. However, in the middle time, from 1849 to 1850, there was a penumbra in which some of Anglo-American lawyers began their activities. And it's a case of one Stephen Field, who was appointed alcalde in the town of Marysville, California. The alcalde, as you may remember, is a position in the civil law tradition by which these authorities decide the cases in the name of the Mexican laws, in the name of Spanish laws. Spanish laws were very influential in some of the southern states of the United States, As a matter of fact, for instance, the Texas legislation on real estate and the regime for marriage is derived from the Spanish and Mexican laws. The community property that they have and the laws regulating the water and the land, they derive directly from Mexican and Spanish laws. But the interesting case of Stephen Field is that he had the beginning of his judicial career as alcalde from the civil law tradition, but later on, he ended up as a justice of the US Supreme Court. Stephen Field had this capacity to adapt the civil law for the cases in that period, but also he was formed in the common law tradition. This is an example of how two legal systems combine and can coordinate in the development of the law. Now, I think that with this consideration, we may advance a little bit about how this common law and civil law began and how they separated each other. Why the common law is characterized as a judge-made law, and why the civil law is based on the concept of codes and laws. Let me begin with the common law. In my opinion, the common law origin began, of course, many years previous, but began like the Battle of Hastings, the invasion of Normans to England in 1610, with the decision of Edward Coke in England. In one case that is insignificant is the Bonham case. This Bonham case dealt with the profession of practicing medicine in London. Once that this Thomas Bonham had been graduated in Cambridge University in physics, that means in medicine. He wanted to begin his medical practice in London, but the problem is that he couldn't do it because in London particularly, they had an organization that it was the only organization to authorize the practice of medicine in the city. And they had the monopoly to authorize this authorization. Thomas Bonham, even though he had been a brilliant student from the Cambridge University, he couldn't do it. He was not authorized to practice medicine. However, he practiced despite the lack of authorization in London. He was sent to jail by disposition of the Royal Academy of Physicians in London, which is a private organization empowered to send and inflict, send people with disciplinary rules and inflict some penalties when they don't obey the instructions. The case was raised before the court of Edward Coke, and Coke established this fabulous disposition, very short. It was not a disposition of hundreds of pages like we are accustomed to read, but this judicial resolution, in short, was against the royal prerogative because, in fact, the problem with Bonham was the enforcement of two contradictory ordinances, both of them dictated by Henry VIII. To end the explanation of this case, that you will find it in internet, and you will find it in many books. Edward Cook explained the relevance of precedents. Precedents were important for the legal system in England. Cook couldn't base his resolution on the legal written dispositions of Henry VIII, because as I explained, the dispositions were contradictory. One disposition and other disposition later explain the issue differently. And therefore, Cook, instead of relying on the written ordinances enacted by a king, he preferred to look for precedents in the courts of England. At the time, it's amazing the historical records of England, because they have historical records since the 13th, 14th century, written in books. And at the time, Bonham found different precedents that they were establishing, that when there's a contradiction in the laws, the judge should enforce the legal reasoning, look for the reasons behind the resolutions, and to enforce that resolution, that reasoning, to a new case. And this was the way in which Bonham decided that there was higher laws and there were other laws that they were not have the same authority. Cook phase, of course, is 1610, is the beginning of the 17th century. Cook faced a big political problem, of course, because by using that method of reasoning, he confronted the royal authority. He said that law, even though has been enacted by a king, this inconsistent with a higher law. The concept of higher law comes from England, even though England doesn't have a constitution. Higher law that is based on the legal reasoning, on the common law of the country. And probably that's the name of the system. It's the common law of the country, the law that is common in the courts. And he finally decided in favor of Bonham. Cook could face execution, of course, for these kind of things. But the Stuart dynasty that was taking over England, the Tudor dynasty had ended with Elizabeth I. The dynasty of Stuart were a little bit flexible in that sense. So flexible that years later, Charles I was executed and beheaded by order of the parliament. That is, for me, the beginning of the common law as a judge-made law. The judge should not trust or rely purely in the legal wording of the statutes. The judge should look first for the judicial background of each state, the pertinent law that is applied, has been applied in different precedents. For instance, Cook looked around 5 or 6 precedents for deciding this case. And that's exactly very similar to our concept of jurisprudencia. Our concept of jurisprudencia, was adopted in 19th century for Mexico, always you look for precedents 5 presidents in a row to make a jurisprudencia. In common law, we don't use jurisprudencia because jurisprudence is translated as a philosophy of law. That is not the meaning of the civil law. Now, the civil law is based on the concept of code. And the concept of code was exactly the legal reasoning behind the laws. Instead of looking for precedents, of judicial precedents, we tried to create a law that it contained the legal reasoning behind all the laws around, the main dispositions from all the other laws, and to create a code. And this is the codification movement in France that began in the 18th, 19th century in France. So a code is a legal text, written text, that set the rules in the most precise way to avoid interpretation by other authorities, primarily judges. You remember that the French Revolution had not only the king as a symbol of authoritarian regime, but in the French Revolution, there were judges who were considered to be part of the conspiration in favor of the king, corruption in the system, because each judge could decide whatever way he wants in order to secure the interest of the superior class. So judges were the enemy in the French Revolution. And that is why during the revolution, and based on the work made by distinguished jurists in France, they adopted the methodology of creating a code that it would contain the general principles of law, inspiring all other laws. And the code will be the symbol of unification of the legal system. And in that sense, a code will be also a way to separate the authority of the lawgiver from the judge-made law. Now, in 1870, we adopted the codes in Mexico. And we made a complete decision to restrict the interpretation of the laws and the codes by judges, by inferior officers of the law. Interpretation by judges was forbidden in our system. In the Constitution of Mexico of 1857, the interpretation was eliminated as a power by the judges, and the judges only will repeat the words of the law, as the famous saying of Montesquieu established in the Spirit of Law. Congress and legislative bodies will be the only source of interpretation in our system, in the civil law system. And that is also up to the present, although with certain exceptions, every time more exceptions. But you can read the Mexican Constitution nowadays. In the Article 72, Section F of the Mexican Constitution, saying that the interpretation of laws should also be made by legislative bodies and by legislative means. That implies that judges cannot make broad interpretations of the law. However, that regime in 1857 changed in Mexico for Article 14 in the Constitution, of the current Constitution, that it was inspired by Emilio Rabasa, one of the legal scholars at the time. And in Article 14, we read that in the last paragraph of this article, that there are general principles of law that should be interpreted by judges. Therefore, at the end of the 19th century and beginning of the 20th century, Mexico began to adopt principles and rules from different legal systems. In that sense, we have a mixed jurisdiction. Primarily, public law is inspired by the American law. The Constitution of Mexico is, in general terms, very close to the American Constitution. But the way that we enforce the Mexican Constitution is not the same as in the United States. For instance, in the United States, you created the judicial review, which is primarily the fundamental instrument for judges to invalidate laws against the Constitution. This is a fundamental principle, but that principle is not I'm sorry, I didn't know that I have to authorize the entrance of people to the class.
No, don't worry. We are doing that.
Please, because I had one left that I had to authorize it. Well, anyhow, the judicial review was the most important instrument in the judicial world for the United States, and that was taken into Mexico in terms of the Marbury versus Madison case of 1803 by Marshall. And Madison was an interpretation of the Constitution. It was an interpretation of Article 3, because the Article 3 doesn't say exactly that the federal courts are empowered to invalidate the laws inconsistent with the Constitution. There's no disposition in the Constitution of the United States saying that. However, this is the most important power granted to the federal courts. But in Mexico, we had to establish that concept written in the Constitution. And we began the adaptation of this principle late in 1870, when in one case, Antonio Lozano case, was argued by the most brilliant president of Chief Justice that we have in Mexico, Ignacio Luis Vallarta. And Vallarta advanced the same concepts of Marbury versus Madison. As a matter of fact, he quotes the resolution of Marbury versus Madison in the case Antonio Lozano in 1870. And from that year, we began a whole chain of precedents based on this topic. Now, this was the beginning of important institution for us that is called the jurisprudencia, as I mentioned before. The jurisprudencia is a particular institution in Mexico that it was created by Vallarta in 1882. But you know, I mentioned that Vallarta had been Chief Justice of the Supreme Court. He didn't create the jurisprudencia as a resolution of the Supreme Court case. He had to go out from the Supreme Court, and he advised the Secretary of Justice from the federal government to include in one of the legislations regarding the justice, the judicial system, to include the disposition that whenever the court finds that 5 cases had been decided in one sense regarding the constitutionality of law, those form a precedent that in our terms will be jurisprudencia, a thesis of jurisprudencia. So the precedents in the United States are not the same as jurisprudencia, but they have the same effect, the same outcome. And that was created by Vallarta, precisely, taken from the United States. Why Vallarta decided to create a concept like jurisprudencia in the terms that we have it, 5 consecutive resolutions in the same sense of the Supreme Court or any federal court, is a compromise solution. As civil law countries, we are not allowed, we don't have in our background the power in order to eliminate one legislation because it's unconstitutional by a single case. We need ourselves as courts to justify, legitimize the power of nullification of a legislation with 5 consecutive cases. In this sense, I will compare the jurisprudencia with the same effects of the same thinking of Edward Cook resolution back in 1610. When Cook, for the first time, declared null and void one decree of Henry VIII and established the validity of the other decree, he had to look for precedents because he was doing something new. He couldn't just say a royal decree could be annulled. No, he has to endorse and justify by precedents. And as a matter of fact, if we look and we read this case back in those times, we will find that the resolution is endorsed by 4 or 5 cases before, beginning in the 13th century in England. So in my opinion, in my mind, I think that Vallarta, because Vallarta knew very well all these background precedents, Vallarta tried to emulate the same reasoning Edward Cook had made back in the 17th century. And that's why the jurisprudencia was created in Mexico at the end of the 19th century with this procedure. Let me also say that we are now in a time in which we think and we reconsider the concept of jurisprudencia, and we are beginning to endorse the fact that one single resolution of the Supreme Court is enough to invalidate the law. We don't need to repeat the same conclusions. We did that before because we didn't try to seem a little bit rules, and one judicial resolution could be the same as one legislation. But we are moving towards it, and this is the influence of common law into our civil law tradition. Let me also mention that in our history, the common history that we have between the United States and Mexico, especially in the northern part of Mexico, southern part of the United States, we have a lot of interesting presentations. For instance, when we were talking about the immigration between the United States and Mexico, we should consider that the immigration began to be regulated first by Mexico. In 1830, there was a decree of the Federal Congress that the immigration began for the United States into Mexico, because we accepted the immigration of colonies from Tennessee, Arkansas, and all other states into Texas. There was a kind of like always in the immigration movements begin. It's a wave. It was a wave of movement of immigrants into Mexican Texas. And in 1830, we saw that as a danger. The same way that is in the United States considered now. It's exactly the same. History doesn't repeat without any coincidence. And the Mexican military mentioned that it will be a danger for the national security of Mexico to invade by immigration the Texas territory. And the General Mieri-Terán suggested that that immigration should be controlled. And we were the first to create the passport concept in the border of Texas and northern Texas and Mexico. And we also tried to enforce these immigration laws. Fortunately for the United States, we couldn't enforce it, which is a kind of lesson that we should repeat nowadays to the United States. And at the end, that was the main argument to call for independence of Texas. As you know, Texas was part of Mexico, but Texas was part of a northern state of Mexico, Coahuila and Texas. They were joined together. So Texas wanted to split from Coahuila, and they called the independence of Texas in 1836 for that purpose. And that was the beginning of the secession of Texas and the invasion of the United States into Mexico. But it's paradoxical, these coincidences that we see in our history. Now, just a little word about certiorari. That I don't remember the name of the professor. I think that it was Professor Lewis, who now I'm impersonating him as according to the presentation, to the lady who introduced me. I'm Lewis, so I'm taking the Lewis part of me. And the certiorari, although he didn't specify that this certiorari, he pronounced it a very rare, very strange, but this is about the certiorari. It's something very interesting that we should adopt. As a matter of fact, I proposed it to the Supreme Court in Mexico to adopt the certiorari, which means a way of contention of the flow of cases to the Supreme Court. According to our system, all cases arising under Constitution and federal laws may be known and decided by the Supreme Court, but they decided or they decide which ones will study. From all the cases submitted to the Supreme Court in the United States, very few are revised by the Supreme Court. And this is good because the Supreme Court selects the cases. This is not consequences of denial of justice, because the cases had been adjudicated before in previous courts. So if the Supreme Court decides not to hear one case in particular, that case has been decided by the other instances previously to the Supreme Court, and that's the end of the discussion. It's res judicata. But some cases are interesting in which the Supreme Court considers that it's important to decide and to pronounce the final word in each of these cases. So the certiorari is an interesting institution that could be adopted in our country as well. And I think, I hope that some kind of institution could be adopted in this way. Now, if I have some time, I ask the organizer how much time I have.
Well, an hour has passed, and we have some questions yet.
Okay, I'm going to end up my presentation with this. What is the challenge for the Mexican legal system in the future? And this is why I strongly suggest that foreign nationals, foreign lawyers, I mean Mexican lawyers in foreign territory, of course, they should think about one thing in particular. Mexico now has the opportunity to create standards in comparative law and international law. And I'm aware that I'm referring to people who are in the United States, and you might live in Chicago or Illinois or other states. And this is important for you. The tradition of the American law is overwhelming, especially in human rights. That should be interesting for us to pick up the best precedents and try to enforce them, or try to suggest that we might adopt some kind of argumentation, like Vallarta did with Antonio Lozano in 1870 regarding the Marbury versus Madison. But Mexican has the opportunity to absorb, let me use this expression, the comparative law, not only of the United States, not only of Canada. Canada, for instance, has important precedents on language rights and Aboriginal rights, but also to absorb the jurisprudence of Europe. Behind, you will find an interesting detail of a session of the Venice Commission. Behind, I have a picture of the commission when they work discussing the constitutional issues, electoral issues, political issues of the states in Europe, that they are very interesting and very important. So Mexico could learn from these experiences. Mexico is representative in the Venice Commission. Mexico has comparative law studies. For instance, the creation of the Institute of Legal Research of our university was first created as a comparative law section of the law school. So we are prone to absorb this background. In contrast, in the United States, they are self-sufficient. They don't rely too much, is my opinion, personal opinion, on comparative law and less international law. They are the legal system with T, capital T, the legal system. And very rarely they look over other systems in the other countries or even the international law. For instance, there's a case, Roper versus Simmons from 2005, that is a case in which the Supreme Court condemned the death penalty for minors when minors commit a capital crime. And as you know, the United States enforced the death penalty in 25 at least states of the 50. And in some states, they don't make any differentiation between a minor or an adult. And in Roper versus Simmons, they were condemning a minor to death. This is the first time in 2005 in which the Supreme Court, through the Justice Kennedy, mentioned that is against the common international law to condemn to the death penalty to a minor. So this is something that is not accepted by the international community. And it was the first time that the Supreme Court accepted this international community standard into the resolution of American common law. For that, we ourselves don't enforce the death penalty, and therefore we don't have these problems. So this is an interesting case. But I think that Andrea now has the word. Go ahead.
Thank you, Professor. Now, if you agree, we shall give answer to the questions made by the audience. Okay, well, the first one is, now that we are approaching the US legal system with the precedence in the new type of jurisprudence, do you consider a good idea to restrict the lawyer's work jurisdiction to one particular state in Mexico, just like the US? And what do you think about a general exam for every lawyer in order to work as an attorney?
Well, there are too many questions in your question. Why don't you dissect the questions? The first one would be what?
Now that we are approaching the US legal system with the precedence in the new type of jurisprudence, do you consider a good idea to restrict the lawyer's work jurisdiction to one particular state in Mexico, just like the US?
No, the standard in Mexico is national. A lawyer is a national practitioner. I don't see how can we restrict, and which states could restrict that. Now, being neighbors, the United States and Mexico, if one state in Mexico restricts and the other one does not restrict, it would be a force that we couldn't resist the restriction. So it wouldn't guide us to a practical resolution. I don't know if that's the answer, but if that's a question as well.
Okay, thank you. And well, the second part is, what do you think about a general exam for every lawyer in order to work as an attorney?
A lawyer working as an attorney?
Yes. No, see, the exam for the lawyers
The bar
to work.
exam?
Uh-huh.
Well, no, it wouldn't be compatible for the Mexican system to have, after a graduation in law, to establish a bar exam. Bars in Mexico, I think they couldn't really be applicable because they will be hostage to political interests, economical interests. The system that we have, even though it's imperfect system by universities, I think is the ideal. To go for an exam, a bar exam afterwards, the university degree, it would be a second stage of limiting the practice of law in our country, and I would endorse that.
Okay, thank you. Why are some states from the US more attractive for people to become a lawyer than others?
Well, the reasons are different. For instance, if you want to practice law in Iowa, the job that you have in Iowa as a lawyer is reduced that if you want to practice law in California. And the requirements are different, and the interest for living in one state and working in another state is they are different. That is the reason I say.
Okay, well, the last one is, what do you think Mexico could learn from the common law system since the new kind of jurisprudences?
Well, one thing that I mentioned is that the power to give interpretation to the judges should be accepted in Mexico. The broad power to do interpretation for judges should be accepted in Mexico, and therefore, by empowering the judges with broad interpretation, like for instance in the United States, for us, we need to have a written statement in the law in order for the judge to be sure that the judge could be adjudicate one case. For judges in Mexico, there's a burden of political and responsible function to adjudicate cases plainly on the basis of written statements in the law. If they don't have that, the judge could be in serious problems, because under what basis the judge made the resolution? Because in our thinking, a judge could only enforce the laws that they explicitly given with the solution of the case. For the common law, judges precisely react to situations in which they are not obliged by the legal written statements. They have to interpret. They have to make interpretations in which the law is absent. Therefore, and they don't entail any responsibility for doing that. On the contrary, that's the work. But for us, we don't consider that function to be proper. Okay, Andrea?
Okay, thank you so much for the lecture and
You're
for
quite welcome.
answering.
You're quite welcome. Now, let's have lunch.
Well, now, Dr. Erika Erdely-Rees, Academic Coordinator of Chicago UNAM, on behalf of the Faculty of Law and Chicago UNAM, is going to close down the seminar. So please welcome Dr. Erdely.
Hello, everyone. It's my great pleasure to be here at UNAM Chicago, greeting you after this wonderful series of talks on this webinar, Relevant Aspects of the North American System. Thank you all for attending. We hope this has been an enriching experience for all of you. I definitely agree with Professor González Oropesa that it would be important to include Canada in the scope of these talks, and we will definitely keep working together with the Facultad de Derecho and División de Estudios de Posgrado de la Facultad de Derecho to bring you more opportunities like this to think of your profession internationally. I would like to encourage you to come to Chicago to have an in-presence experience with people like the persons you met during this webinar that will be happy to receive you here. During the summer, we have a program called Professional Visits for Lawyers. It's a short program that happens in June. And you could come and have this direct interaction with judges, with students, with professors, and have a complete experience. So please keep in touch, contact us at UNAM Chicago. I will ask my colleague, Marco Antonio Fuentes. He's in charge of the professional visits programs for lawyers, to share his email address in the chat, so you can all contact him and know about more activities like this. Join our database so you can receive information about other programs that we will be preparing for you together with la Oficina de Vinculación Internacional de la Facultad de Derecho, represented by Trilce Ovilla Bueno, America Erdely, Academic Coordinator. And I thank you all very much, and congratulations on this successful webinar. Bye-bye.